All right, what we have here today is the state of Tennessee, or actually it's Jimmy Reeder's post-conviction relief petition. It's the state of Tennessee versus Jimmy Reeder is the style of the case. But this is dealing with the post-conviction relief petition that Mr. Reeder has filed. Mr. Reeder, what I want you to understand is that there are a number of issues that you have raised in your case, and you have filed a third amended post-conviction relief petition. Then you have sent, that we had set for today, but due to the fact that you had sent a letter in the last part of October to our clerk's office, and you had requested apparently 15 witnesses to be subpoenaed, then I need to address those witnesses that you want to have subpoenaed and give you an opportunity to tell me why that witness is necessary for your post-conviction relief. You need to understand that this post-conviction relief petition that you have filed, the third amended one, raises certain issues. And any witness that you're going to call has to be directly related to an issue that you have raised in your post-conviction relief. In addition, as I know you are well aware, since you have studied this for now some 8 years that it's been pending, you have also got to raise issues that were not dealt with at the trial or on the appellate level. In other words, if there's an issue that you have raised that was addressed by the Court of Appeals in your appellate process, then I'm not sure that you would, I don't believe you would be entitled to raise that as an issue in this post-conviction relief unless it relates to another grounds for post-conviction relief. So I'm going to give you an opportunity to go through this witness list with Mr. Saul, asking you the questions as to why you want this witness to be brought before the court to testify at that hearing. And then I'll give the state an opportunity to be heard as well. And then we'll go from there. Now, the nature, I'll give you a chance to speak, but you just wait for me. Well, I'm going to give you an opportunity to be heard, but what I want to explain to you is this as well. Due to the nature of the charges against you, we're not going to go into the identity of the victim in this case. That will not be brought out. And as a result of that, I'm cautioning you not to mention the name of the individual that was the victim in your case. You've gone through the appellate process. You were found guilty at trial. You've gone through the process of appeal that has been affirmed by our appellate courts. And this is now the post-conviction relief, which is limited to certain things. So at that point, is there anything before we proceed through this from Mr. Saul or General Sagi that you wish to address? No, sir. All right. So that we're clear, we're going to allow Mr. Reeder the opportunity through counsel questioning him to bring to this court's attention why you need these 15 witnesses. And then I will address those issues. So,
I'm not really going to be able to speak on not interrupt you, but I can clear all this up really, really quick. And
have a seat and come up here to the witness stand if you're going to address anything with the court.
I need permission to speak all the things that happen in the case.
Just have a seat in the witness.
Not to be questioned, because the problem is him, not me. The problem is my attorney. So you're forcing an attorney on me that's not my choice.
I want you to raise your right hand and be placed under oath.
I affirm.
Do you solemnly swear and affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I affirm.
Have a seat. You affirm, that's good enough. Now, Mr. Saul is the 8th attorney that you have had in representing you on this post-conviction relief petition. I am not inclined to release Mr. Saul and find some other lawyer to appoint to represent you. He is.
Then I want to represent myself, Your Honor. 303, I'm giving you a notice of it. I want to represent myself. He's not done anything. Tom said he didn't ask you permission to get my witnesses today, I asked you in Dixon County, I mentioned this case. And I told you about the witness. I told you I wanted to go after the jurors. I'm not, Your Honor. I'm not trying to be ugly. But I asked you on the record about Thomas versus State. I brought it up, and you said, no, it's okay. You can't investigate the witnesses or get any funding to investigate the witnesses.
I'm not trying to get ugly.
The jurors, witnesses, as my witnesses summons, I told you that about that. I mentioned it on the record, Your Honor. And that day it should have been went over. If the state wanted to contest it, they should have done it that day on these witnesses. I told you I had witnesses, I had the summons, and you said that I could put my own in, and the clerk would help me on the record, Your Honor. I'm not trying to be ugly, but they didn't contest it that day in Dixon County. State, and this is Thomas, right? I know the rules. And under Rule 8, it didn't say I had to ask permission to summons. It says I had to have permission to investigate them under Rule 8. And Thomas' case right here, I have right here, Your Honor. It doesn't say that I have to have permission. The State versus Smith, he brought his jurors. Faulkner case brought his back. Hill brought his jurors back. The Vanderbilt case brought his jurors back. And Rollins brought his case back under the same issues that I'm going under, Your Honor.
All right, put that piece of paper down. Now, we're going to address, first of all, your request to discharge Mr. Saul as your attorney. You understand that you need an attorney to help you with these issues that you've raised, and that an attorney is required to adhere to the rules and to the law, and can only raise those issues that this court or that the law allows you to raise on a post-conviction relief. And under the circumstances, because of the fact that you have subpoenaed, for example, your first subpoena on your list is the District Attorney General for the 23rd Judicial District, Ray Crouch. You have requested a subpoena for him. Typically, that is not something that would be allowed by the court to subpoena the district attorney unless there's some showing of a need or reason why. My intent is to allow Mr. Saul at this stage to simply allow you to state in a question and answer format why you believe each one of these witnesses is relevant to your case, and then I will consider that, and then I will make a ruling as to whether or not that subpoena should or should not be brought forward. Then my ruling will be an issue that you will have to, again, appeal. If you disagree with my ruling, you'll have the right to appeal it.
Yes, sir.
But I'm trying to simplify this procedure so that everybody's on the same page. So I am not going to grant your request to discharge Mr. Saul at this stage.
Right. Now, we want an interlocutory appeal on that, Your Honor.
Pardon?
Interlocutory appeal on that. Under
Right.
Cook versus State also, under recusal, I want you to recuse yourself if you're not going to let my enforcement attorney on me. It's not doing his job. You have all my motions. You haven't went over none of my motions that I put in against Mr. Saul. None of them. He got somebody convicted of their own car, sitting in their own car.
Are you requesting that I recuse myself from your case?
I am. If you're going to force the attorney on me, that shows that something's not right here. That something's going on. I admire you. I try to respect you, but I just do not understand why you have not went over my motions at any of them. You haven't. You're just saying you're not giving me no benefit of the doubt whatsoever. You're not having went over none of my motions. I put 4 motions.
I admire you, and I kind of respect you. The look on Wolf's face was fantastic.
And to get him off because he's not doing his job. I can prove it if you allow me to. I can prove it.
All right, stop.
And we're here now.
Stop talking.
Yes, sir.
Under Rule 10 of the rules of the Supreme Court rules, when a motion is made for the judge to recuse himself, and the judge cannot proceed until such time as he has entered a written order to address that motion. So I will step off the bench and I will issue an order, and then we'll resume this. Have a seat.
I said only if you're allowing me to keep this attorney, Your Honor. And I apologize to you for being abrupt to you.
Mr. Reader, I have drafted an order that will be entered on the record that denies your motion to recuse this court. So we may now proceed with the question and answer form. I want you to understand one thing. What I'm doing today is to try to address your request regarding these subpoenas. And the simplest and most expedient way of doing that is to have Mr. Saul, who I understand you have issues with, but today at least, we're going to let Mr. Saul ask you the questions about why you want this particular witness and what they may prove or what they may establish in relation to your post-conviction relief. Then the state will be able to ask you questions. I will then have to issue an order regarding which of these subpoenas, if all of them or some of them can be issued, and they will be issued before the next hearing. All right. So if everybody's on the same plan, the sooner we can get through this, the quicker we can get a resolution. Yes, sir.
Well, I have intent to use. We can go over that today. I got also intent to use evidence in the post. We could address that if you want to. I got
All right. What evidence? Pardon?
Also, I have the jurors I want, if they do come, or the witnesses I wanted to be sequential, because the last time allegedly the DA talked to him before he came in to the new hearing, allegedly. But so I do want them to be sequential. You know what I'm saying? I got law to back that up, Your Honor.
All right. Well, number one, none of those witnesses are going to testify today because I'm going to have to resolve the issue about whether or not they should or should not be called. So keep in mind that today is all about you satisfying me that there is a legal and relative basis for those witnesses to be brought in to testify. So, Mr. Saul, I'm going to allow you have a copy of the handwritten list that he provided?
Yes, Judge.
All right. And if you will, please address each one of those. General, do you wish to let him go through the entire list and then cross-examine him, or do you want to do it as per witness? All right. So what we're going to do, so we're all on the same page, Mr. Saul is going to ask you why you believe a certain witness should be brought in under a subpoena. And then once you have testified about those reasons, the state will be allowed to then come to the stand and question you about, cross-examine you about the reasons why you've given. And we'll go through all 15 of your witnesses.
I think there's a few more I added, Your Honor. I'm sorry, I don't mean to interrupt you. There's a few more that I added.
2 more that you added.
Yes, sir.
And who are those?
Yes, sir. It was, I believe, 2 or 3. Mr. Fouch, he was one of the jurors, and then Miss Thomas.
I don't have
And
them in mind.
Miss Gazea, it's G-A. I mean, I have the list in my stuff, but and then it had Z and then an I. She worked for Vanderbilt College.
All right, if you, well, I have 15 witnesses that were on the list you supplied on October the 28th. So if you have 2 additional ones, you need to go step down and retrieve those. All right, let's go ahead and start with the first on the list and move over. We'll work down to it and we'll get to the one he's added. So.
Yes, sir, Judge. Mr. Reader, if you could, just state your name for the court, please, for the record.
Pull that microphone down so that you're speaking more directly into it.
Okay. Mr. Reader, will you state your name for the record, please?
Jimmy Lee Reader.
All right, Mr. Reader. Number one on the list that we've spoken of regarding potential witnesses for your PCR hearing. The first one I'd like to talk to you about is Mr. Ray Crouch. Can you tell the court why you feel it's necessary for Mr. Crouch to testify at your PCR hearing, please?
Yes, sir. Well, motion for the new trial. He made allegedly false statements due with a motion in limine. When he said he wouldn't let any character evidence come in, and agreed to it on the record to the judge, and they all agreed to it. And my recordings were all character assault and talking about other people that wasn't relevant under State versus Moore. And it was supposed to be retracted everywhere that they agreed to it. It was supposed to be, even the appellate court, it's in my brief, it says that they agreed to it. It was supposed to be retracted. Anywhere I asked for an attorney, the jury wasn't supposed to hear that. For what reason, I do not know, because it seemed like to me it'd be more of an issue under Miranda warnings and issues of talking about attorney. And, you know, under Arizona case, that it wasn't really supposed to come in anyway, but that they asked for it to be retracted. Also, he said on the statement, well, we're not going to let it come in unless anything about his prior records or anything like that, unless he gets on the stand. Well, State versus, I believe it's Smith. You can't put somebody in fear to keep them from getting on the stand. Not only that, they alleged, he assumed, which I think he thought it, that there was only a letter, and that was the motion that Mr. Baum and him agreed on. But it was really talking about, Mr. Baum didn't put the motion in correctly. He was supposed to put in, you know, the 404B ruling, and, you know, 404(1), 2, 3, and, you know, and relevance and all that kind of stuff. Judge Sexton, I believe it was. It was supposed to, but they were alleging that the state was alleging all they had was a letter. They didn't even say anything about using my recordings or anything at that time. And so I'll give Ray the benefit of the doubt. Maybe he just didn't know that they were talking about the letter and not about the recordings. So we have to bring it back to clarify that. And then Mr. Wilson was there also during the new trial, and they could have just put him on the stand, which they asked, do you want to put Mr. Wilson on the stand to answer several questions about certain issues they agreed on, but Mr. Baum felt it never did that. So I need to also Mr. Wilson for that reason too.
All right. So I don't want to continue into we'll talk about Mr. Wilson in a moment. So essentially what you're saying to the court is Mr. Crouch would be necessary because he would need to be able to articulate whatever the agreement was regarding a motion in limine regarding your Fifth Amendment rights and when you invoked your right to counsel.
And character assault, the Tennessee rules, they ruled on not to let any character evidence before my trial. It's in the, I have the motion in limine with me right now.
Okay.
And it says that he agreed on that for it not to come in.
All right.
Also, Mr. Krause needs to come back also because it's a jury issue. That he played football with the juror, and he also went to school with the juror. That is allegedly Mr. Fisher, Robert Fisher, Robert Allen Fisher. So he went to in school with him on that issue, and he was asked by the court several times, do you know any parties involved in this case? And he never came forward about, actually kind of knew me a little bit through just we do contractor work and stuff and everything. But he also, we're dipping into narrow, we're dipping into Robert Fisher on another witness, but they're tied together on that issue.
Okay. Ms. Say you have some questions for you about Mr. Crouch. Thank you.
Morning, Mr. Reader. Hello. So just a couple questions about General Crouch and your trial. Can you hear me okay?
Yes, ma'am.
Okay.
I do have trouble hearing you.
So you said that you needed General Crouch to come back because he had knowledge of a juror. Is that what you're trying to assert?
No, he had knowledge of Well, I don't think he had the knowledge. That's a problem. So we had to clarify that. I think that he thought it was he says on the record, he thought it was a letter that had to do with the motion in limine and not that had to do with my recordings, which they should have had, Mr. Baum should have had that clarified up before my hearing. My trial. He should have had it clarified.
They did in fact discuss that on the record at trial. There was an objection about that, wasn't there?
They had a bench conference about the issue, and he didn't mention anything about the letter, but he did mention it in the new trial. But they said, well, we can have Mr. Wilson's here. He can clarify it up if he wants to get on the stand, if he's talking about the letter or he was talking about other things. But he's also said that he would let no character evidence, I got the motion in you with me, that no character evidence come in. The whole recording is nothing but a character assault. I'm talking about things to do with my ex-wife, things that we with this custody issues, my niece, some things happened with her allegedly with my son, and some things, and the jury's getting to hear all these irrelevant things because why? Because they didn't hold up to their agreement, the state did. And Mr. Baum argued that at new trial, but they didn't put Mr. Wilson on stand to clarify all of it with Mr. Wilson.
Okay, but all of this, we actually have a record of what happened at the motion for the motions in limine, right? Mm-hmm. And we have your trial transcripts, and we also have your motion for new trial where this was discussed, right?
Yeah, and it has exactly that. Mr. Crouch is talking about Mr. Jones, like putting him on the stand, like he's talking about something to do with that. And then when we come up for a new trial, he says he's not even talking about that during the motion. He's talking about one of the officers. I have to look at during the motion of the trial, but it's in my petition where he says that that he thinks, oh, I'm thinking about this, but he clearly knew what he was talking about during the bench conference, because he said Mr. Jones in the letter, but he didn't say the officer, so he swapped it around when he came to the new trial, so that wasn't correct.
So what I'm hearing is that you have a legal objection to something, some evidence that might have come in at your trial, and not necessarily about General Crouch, but what happened at your trial.
404B ruling, Mr. Baum and Mr. Crouch didn't have it clarified. Also, they put fear in me not to get on the stand because he said that if I got on the stand, that he was going to bring, ask me questions about my past and other things like that. But if I didn't get on the stand, that he wouldn't. And he put fear in me not to want to get on the stand in that issue. And in my brief, you'll see that there's cases backing it up that you can't do that to a petitioner.
So what I'm hearing is really your issue is with Mr. Baum and how Mr. Baum handled something, not necessarily what General Crouch said in the courtroom.
He didn't say in the courtroom. He said that at the bench trial, he said that he didn't clarify that he was talking about a letter. So Mr. Crouch thinks he's talking about a letter. Mr. Baum may be trying to trick the state. I don't know by putting statements in. But either way, Mr. Baum failed to do his job. And I'm not saying it's all on Mr. Crouch's part, but it was confusion between him and Mr. Wilson. So it has to be clarified. That's why we need Mr. Crouch here to clarify with Mr. Wilson to find out exactly. So there was no letter. Let's put that to the test. I do not know why they mentioned the letter or how they got the letter involved. There was never a letter from Mr. Jones about me saying I did something as bad as murder or some kind of type. Never was. If you can prove it or show it to me, I'll be glad to read it, but there never was. I don't know where that came about. Mr. Baum knew exactly what the recording said. And they asked me, I think one time, and it's somehow or another, it's on the recordings multiple times, allegedly. But me talking about that statement I just said about supposedly, allegedly doing something as bad as a murder, but it's never nowhere on the letter. And they never called Mr. Jones to the stand. And he said he was not using any character evidence. They both were confused about the character evidence that was supposed to come in, but they did agree on not to, they agreed on to retract where I asked for attorney multiple times. I mean, multiple times. I mean, I'm low educated at the time. Of course, I've improved a little bit. I had my disability at the time and stuff because of that. And I have records to back that up, but of course, no one has looked into that. So.
So,
anyway.
Mr. Reader, I'm just gonna ask you
I'm
to
sorry, go
put a
ahead.
pin in that so I can ask you
I'm
a
sorry, I'm getting
follow-up
off-
about a
off the-
different
off the trail,
question.
yeah, but I'm
You
sorry.
talked about a juror that you said played
Yeah, put a pin in
football
that.
with General Crouch, and that's an allegation. Is that one of your
We'll circle
allegations,
back.
that there's a juror bias with that individual,
Mr. Crouch.
with that juror?
Mr. Crouch's wife went to school with my ex-wife. We had custody of my kids. I put a motion into, I asked my attorney to put a motion in to recuse himself from the case because and him and his wife, plus she worked at the paper and stuff. And I put multiple things in the paper and stuff, but not for that issue so much as it is my ex-wife at the time had custody of my kids. Supposedly he did say that he tried to talk to her on Facebook, but supposedly she wasn't answering. I don't know if that's a fact or not, but
So
he did
I was
say that.
specifically asking about the juror that you said. You mentioned a juror that played football with General Crouch in high
Yes,
school, and you
yes,
thought that was a,
Yes. Robert Allen Fisher went to school allegedly with him.
now, Mr. Reader, you would agree if you went to school with probably a lot of people, right?
When you ask a question, you're supposed to answer it. You're supposed to respond.
Do you know
That's under the,
do you know
rule under
everybody?
Owens.
Do you know everybody in your high school? Did you know everybody that you went to high school and all of their names?
They play football together. That's pretty close.
Do you have?
Especially when allegedly your sister made allegedly videos with the football team. And it's the same kind of issue. But anyway, we'll get off on that. But yeah, there's other reasons they can be brought up.
So are you alleging that Mr. Robert Fisher made false statements? Is that what you're alleging?
No, I'm alleging that Mr. Robert Fisher,
Yes.
Alan Fisher, did not come forward and respond. And it's a Supreme Court ruling that you have to respond to questions in order. It's in my petition.
Your Honor, I'll pass the witness.
Well, so that I'm understanding and clear on this, if I understand correctly, your need for General Crouch to appear as a witness is relating to what grounds on your post-conviction relief? There's specific grounds that you have to allege. So what grounds are you alleging that his testimony would relate to?
Well, I think it's in the first part and it's also in the last part where it says that the 404B ruling where they didn't retract.
The grounds that you've alleged are ineffective assistance of counsel, juror bias, misconduct by the district attorney in statements made to the jurors. I'm asking you as to General Crouch's testimony, which of those grounds will his testimony relate to?
It's under prosecutor misconduct and I have to look at my petition, look at the grounds.
So I'm just asking if you can tell me how you think his testimony relates to the grounds that you've raised.
Because he agreed to something on the record on not putting any character evidence on, and he did.
Right.
And also he informed me that I could, if I got on the stand, that he was going to use the character evidence against me, which he still used character evidence. My whole recording is a character assault. It's talking about religion. It's talking about other things. It was irrelevant. 441, 402, 3, 404B. They never had a defined ruling on it, and in those settings, and they should have. So we could actually blame it on the court, actually, also, to a sense.
Thank you. Mr. Scott, Mr. Saul, you may ask about the next witness.
Mr. Reader, it's my understanding that Mr. Robert Wilson was the original prosecutor on your case, correct?
Yes, sir.
All right. What testimonial evidence do you think that Mr. Wilson can offer as it relates to your petition for post-conviction relief?
I think it was just rooted in, counsel. It was rooted in what we just were talking about. The same, the main issue was, well, then we have to go into more juror issues. Larry D. Fisher was accused of, indicted for 27 indictments for for child rape and incest. And Mr. Wilson was the DA on his case, along with Jake Lockwood as the attorney, which was my attorney also. And for new trial, we brought back Miss Fisher, Rebecca Dawn Fisher, and asked her specific questions about Mr. Fisher. And she got mad a little bit because Mr. Baum said it was her uncle, and he didn't really have her clarified when, where, and who. The appellate court said the exact offense, the time of the offense, you know what I'm saying, what type of offense, and when and where it happened or whatever. It's in my petition, and it explains all this that I'm saying. They said that, well, we could put him on the stand, and well, they could put him on the stand for that issue as well, and he would have clarified that, yes, Mr. Larry D. Fisher does have multiple indictments and was charged with two, one of rape for 16 years and one incest for 4 years. And if they would have put him on the stand, they could have. I mean, we can do it other ways if under the intent, if they allow me to use the indictment, or let me use his judgment papers, which are public record.
Right. Well, let me ask you.
I don't have to have Mr. Wilson for that issue.
Okay, well, let me ask you this: what testimony do you think Mr. Wilson could offer that's specifically related to the issues you're raising about your PCR petition? What is it that he could say that's related to the PCR?
The issue that compounded the ripple effect, the cumulative effect, where he said that all he had was a letter that he was going to use against me, to Mr. Sexton, in the motion, the first motion, the limiting and suppression motion, and which was not true. As far as I know, there never was a letter. It never was produced to the court or me from Mr. Jones.
So it's really related to the motion in limine and the use of.
Well, it was a ripple effect that caused Mr. Crouch to do what he did by possibly mistake, but Mr. Baum knew that it was not a letter. I mean, there's just no way that he didn't know. I mean, I'll tell you the truth. I mean, maybe he done it for a reason. Who knows? I don't know. That's between him and God. You know what I'm saying?
Okay. All right. Thank you.
General Sagi?
So, Mr. Reader, again, your real issue with Mr. Wilson is really what Mr. Wilson and your attorney, Mr. Baum, agreed to, or anything that Mr. Baum was engaged with Mr. Wilson. That's correct?
The first suppression and limiting to Mr. Sexton, yes, and also the jury issue that he could have put him on. Mr. Baum could have put him on the stand that day and clarified it, and I would have had some kind of alter judgment or something that particular day, 8.5, well, now 9.5 years ago on the new trial. If he would have just put him on the stand, the public court said I didn't ask when, where, and who. Mr. Wilson could have clarified it up, but just put him on the stand.
So really, this relates to the ineffective assistance of Mr. Baum and why Mr. Baum did or didn't do something. Is that correct?
Right. Yeah.
Not the past judge.
All right, thank you. Mr. Saul?
Mr. Reader, the third person you've listed that you want to have come in for your PCR as a witness would be Miss Kim Stringfield Davis from the Child Advocacy Center. What testimony do you think she can offer specifically related to the issues of your PCR?
She's the one from Nashville, I believe, the nurse practitioner, I believe, in Nashville.
Ms. Springfield was the director of the Child Advocacy Center at the time. She was no longer with the Child Advocacy. She is no longer the director, but she was, if I understand correctly, the director of the Child Advocacy Center at the time of your trial. So that would be who she is. Now, Mr. Saul is asking you, and I will ask it as well. Why do you want her brought in to testify? What is it she's going to say that you think relates to an issue that's before the court?
She used a book, two books, didn't bring the books and didn't have the books with her. And the rules that I put into play, I believe the state, it's a Fisher case also. You can't, if you don't have the book in front of you, or the state doesn't have a copy of it, or your attorney doesn't have a copy of it, then therefore you can't use scientific evidence in your favor that it's not presented to your attorney or to the state. And she didn't do that. Also, she made statements about time, delays and stuff. And the Supreme Court rulings, it's clear on it. You cannot make any comments about time delay. I have the case with that. And also, she made statements about
What?
she had 45,000 children that had never, only 1% showed signs of penetration, and ones that she has interviewed. Well, my attorney didn't ask her, you know what I'm saying, on the Chapman case and stuff, he didn't cross-examine her the right way. He didn't ask her, okay, well, those 45,000 children, how many of them were the people convicted, or how many of them people do you know were actually these things happened to them just because they alleged them? Because, you know what I'm saying, he should have, at least the jury should have heard that and her reactions to that statement.
So
because she's making statements that implying that, you know what I'm saying, to the jury, that all those cases could have been, all those things could have happened to them, which a lot of times is not the case, Your Honor.
Mr. Reader,
Or some other situations happen.
I want to make sure I understand. So your thought is, or with respect to Ms. Davis, is that she could be asked some questions that should have been asked by Mr. Baum,
Right.
and then the court can consider whether or not that may have had an effect on the jury's deliberations.
Yes, sir.
Okay. Thank you.
General Sagan?
So, Mr. Ritter, we're discussing Ms. Stringfield, who, as Judge said, was the director of the Child Advocacy Center at the time. If you recall, at your trial, she's the one who had the videos. She's not the one who examined the victim. So why do you need Ms. Stringfield to come testify? She was the witness who placed the two victims' videos.
Okay, I've got her mixed up with Miss Gallatin, probably. Miss Gallatin's the one that I guess was at General Hospital. So we'll have to probably re-ask the questions, I guess, because
Yeah, so-
I had them. I guess I had. That's what I was thinking. I had them mixed up.
So why do you need Ms. Stringfield from the Child Advocacy Center?
I needed her because she had some that were marked. 1, 2, 3, and 4, I believe it was, but then they only presented and it implied that there might have been another recording. I don't know if they ever had, if someone else in the room was recording, or if they even had security cameras that were recording.
Yeah, I think at your trial, they went over that there were two videos for your case, and those two videos were authenticated and placed there, and the testimony was that they just didn't know why they were labeled
Right.
2 and 3. Like those are the two videos.
Right. I mean, that's a good point. We might not need her, but I just figured that she would be there, but for in case something popped up, you know what I mean, that we need to go over with Miss what is it? The one that was, I guess, the one
But that was already questioned. They already questioned that in court. Like they already took care of that.
Well, she said as far as she knows, so that means she didn't take them. So she didn't definitely answer the questions. What I'm saying.
But there was testimony that those were the two videos that went with your case.
That's what I'm saying. But he asked her, was there any more? And she didn't definitely say she said as far as she knows. That's not a defined question. You know what I mean? It's not, I mean, it could be, may not be.
All right. Mr. Saul, we're moving to number 4.
Mr. Reader, with respect to the fourth witness you've listed, it's Miss Allison Goldberth from the Child Advocacy Center. What specifically do you think that she would be able to testify to as it's related to your PCR?
That's the one from the same places, Miss Davidson, I believe.
Right. She's
So,
the same,
well, under
office.
the rules, I need my petition, Your Honor. It has all the set rules, under, when you let a video come in and she wasn't here, they didn't ask her about her training, that the rules say you have to do that. They didn't ask her, how long she's been there. They didn't ask all the guidelines. That's why we have to bring her back to
Okay,
ask her about all the guidelines.
Okay, let me characterize it this way. I think it's similar to what you stated before related to Ms. Stringfield Davis, and that is this. Your thought is, you tell me if I have this right. Your thought is that Mr. Baum didn't properly cross-examine or examine Ms. Goldberth. And as a result, certain questions need to be asked of her that were not asked at trial, so that this court can determine if her answers to those questions would have had an effect potentially on the jury's deliberations. Is that sort of the nutshell
Well,
version?
no, the emission of the video also, well, yes, but the emission of the video, there's the guidelines that the Tennessee codes have set forward to let those kind of videos come in. And if you have to go by those rules, and no one did that. No one even mentioned anything about the rules at that time. And so I have to bring her back and prove that Mr. Baum did not do that, or the court or the state did not go follow the guidelines of how long she'd worked there, and did the person really need to, I'm saying, these
Right, but
videos. It's just like all kinds of
I understand,
guidelines.
but
If I could have my petition, it has
But
all the
here's
rules in it.
Here's my question. If what you're alleging is there were procedural flaws in how she was questioned, then is her testimony really necessary, or can the court just look at that and say, well, Mr. Baum fell below the standard? Okay, but you're thinking that she needs to be able to be here to testify as to what she would have said if she was asked the appropriate questions.
Well, I mean, the point is, I have to prove that Mr. Baum did not follow the guidelines of the codes of letting
see.
video things in that.
Yeah.
And I have to prove that she was, how long she'd been, doing it, interviews, and all the guidelines that come along with that. It's 24 something other code. It's in my petition.
All right, I understand. Thank you, sir.
She'll say,
So, Mr. Reader, are you asserting that Ms. Allison Galbraith testified at your trial?
Miss Alvin Galbraith?
Allison Galbraith?
We're getting these mixed up. If I have my petition, Your Honor, because I cannot remember exactly
I'll allow you to
which
step-
ones.
you may step down and retrieve your copy of whatever you need to refer to.
And excuse me if I'm a Matlock fan.
Miss-
I haven't seen this, but I'm pretty confident the attorney wouldn't have asked him if the witness had testified.
Sorry, just a second, Your Honor.
I mean, I don't know. It's just my guess.
Okay. Miss Gallatin testified. Following, she is the one from the one from General Hospital that did the first interview, that never did a second interview even after the other people did the child advocate. I mean I guess this is Kids R Us, I believe. I mean, not Kids R Us, our kids. And Miss Gallatin testified as an expert. She was qualified as an expert in diagnosis. Ms. Gallatin is the one who made all the statements. So we're going to have to back up. You know, I apologize if I had this in the beginning. Ms. Gallatin is the one that testified, the following about all of the issues that we talked about with the book and about 4,500 children. Your Honor, I apologize. I should have had this in front of me. That's Ms. Gallatin, Your Honor. She qualified as the expert diagnosis treatment of children.
Judge Lee, I don't care.
All right, so re-ask your question and again, to see if his answer now that he's refreshed his memory.
Your Honor, I'm just trying to clarify because Mr. Saul asked about Ms. Galbraith, not Ms. Gallion. So,
I have Miss Galbraith, Allison Galbraith is number 4 on his jury list. Miss Holly Gallion is the second, or is number 5 on his list. So we're talking right now about Miss Galbraith.
I believe she was the one that took the initial interview with.
so to clarify, she did not testify. Allison Galbraith did not testify at your trial.
No, ma'am, that's why we need to bring her back because she needs to clarify because she didn't do the.
How could I have guessed?
Initial interview on under 412 of allegedly Mr. Baum had Mr. Barnhill was allegedly had done stuff to EMG.
So I'm just going to clarify this. So you're asking for Ms. Galbraith, who did the original child advocacy interviews of the victim, to come into your post-conviction to show what ineffective assistance of counsel?
She has to be there to give the statements of her medical records because she's the one that took the intake and she's the one that actually took the interview and she's the one that made the statements about everything. And they asked her if she had any prior allegations against anyone else, and she made those statements in there, or she has knowledge of the alleged things that happened.
So is your issue that your attorney did not call her as a witness?
Right.
Okay, so
I'm so sorry.
okay.
I'm like I said,
I'm just trying to keep these
I'm
clear.
not the smartest apple on the wrench.
So your issue is really why Mr. Baum did or didn't choose to use this witness. Is that correct?
Right. He didn't call her or ask her, and the issues were they were saying in court, because he didn't call her, which in fact that's true. So, and he needed to go over, and they have to be introduced, her medical records, what I'm saying, or her statements during that interview. They asked her if she had any priors and stuff, and it'd be in her statements and stuff. They didn't let any of her medical paperwork come in or any of her statements. Under Rule 412, we have to address that, and that comes into play.
So just for clarification, at your trial, Ms. Kim Stringfield, the director of the CAC, was the witness that introduced the videos of the victim in her 2
Who
interviews.
did now?
Kim Stringfield,
Right,
yeah.
exactly, right.
The interviews were actually conducted by Ms. Allison Galbraith. You want to bring Ms. Galbraith into your post-conviction?
No, again, we're getting them mixed up again, and I apologize. I apologize. I'm getting them mixed up with the one that did the initial intake in General Hospital. That's Miss Allison Martin, I believe it is.
But right now we're talking about Allison
Right,
Galbraith, the
right,
lady
right.
that did the
Right, I
interviews.
apologize.
Okay.
Yes, ma'am. I'm
So,
sorry.
and your issue really is not with the interview, it's the fact that Mr. Baum didn't call her as a witness. Is that right? So it's really Mr. Baum that you have the issue with.
Right.
Okay.
Mr. Baum didn't call her as a
All right.
witness. And
Thank you,
not
Judge.
only the reason of that is because, she was supposed to, you know what I'm saying, that, under the same guidelines, under letting the interviews come in. She has to be here before they.
But that's an issue that's an issue with Mr. Baum.
The issue is that, yes, but she wasn't here to say how long she's been working and all the guidelines that has to go through with letting child, videos come in, and they didn't go by any of the guidelines, and she has to be here before and ask them all the questions. Miss Davidson wasn't the one who did the interview, so they have to bring her.
And that was explained at your trial, and but right now your concern is that Mr. Baum
Correct.
did not. Okay, thank
Correct.
you.
I'm so sorry. I should have got all this name straight before.
All right, number 5 is Holly Gallion.
Mr. Reader, you've mentioned her in some of your previous testimony, but I want to make sure we're clear. Number 5 on your list is Mr. Holly Gallion from Our Kids. What's the testimony that you believe she can offer that's specifically related to your PCR petition?
Miss Holly Galvin, like I said, I apologize for getting them. I got them confused and stuff. I didn't have the paperwork in front of me. I apologize to the court and to the state. But Miss Gallatin was the one who came, and she was the nurse practitioner, and she's the one to make the statements about the 4,500 children that I was talking about earlier. And she's the one who had the medical records, and that's the reason I really needed to bring her, because to bring the medical records into play, because they have allegedly and have all the statements of prior accusations against someone else, against Mr. Barnhill.
Okay. So your thought is that she wasn't properly examined by Mr. Baum.
Exactly.
Okay.
Exactly. And I think there could have been several questions you could have been asked on all of them, and about the book that she brought in. I needed to, she made these allegedments about all these things in the book that I'm saying it's normal to be normal supposedly about this book, but Mr. Baum never got the book. You know what I'm saying? And it says in my petition, the law that I got with it, you can't borrow other people's scientific evidence like that, and so especially without having. And the case was overturned because they didn't present the books to the state or present the books to his counsel.
Understand. All right. Thank you, Mr. Reader.
Bill Segi.
So, Mr. Reader, again, this witness, your issue is really that Mr. Baum failed to do something, right? But Ms. Gallion's testimony is she was an expert witness. Do you remember that? She was qualified as an expert at your trial. And so we have all of her testimony, but your issue again is that Mr. Baum didn't effectively cross-examine her or give you information. Is that right? You wanted a treatise that she referred to?
Well, also, and Mr. Cross made statements in his closing arguments that she didn't, it's in my petition that she didn't actually make. She made allegedly comments in her petition. Mr. Crouch in his closing arguments that he alleged that she said that she didn't. And I need to bring those issues in. I believe it will come out into the petition. I mean, even if you do a post-conviction, things can still evolve and come out, and there's several reasons why you need the witnesses, because it can evolve, and you can preserve that for the appellate court ruling under 403 and other things.
But under your
I mean,
petition,
103, I'm sorry.
Ms. Gallion, you want her because Mr. Baum failed
Right.
to do something. Ultimately, Mr. Baum you're trying to allege that he was ineffective because he didn't ask for a book, a treatise, or object in a
The two
closing
books-
argument.
The two books, one was Normal to Be Normal, and then another one was in 2000, and Nurse Practitioner book. And I have the law in my petition to back it up, that it says that you're not supposed to.
But again, that's an issue with
Official case.
Mr. Baum not doing something.
Yes, well, I mean, Mr. Crouch can testify that he, and she can too, that she never provided one to the state nor to Mr. Baum. And that's what the case that I got in here is about.
But just to keep focused, the petition that you have is ineffective assistance of counsel with Mr. Baum. So the proof that you're looking for here is
Right.
that.
The
Okay.
issue is about.
Thank you.
I'm sorry, yes.
All right. Number 6 would be
Yeah, Mr.
Jaha
Martin.
Martin.
Mr. Reader, you mentioned in your list of witnesses, number 6, Jaha, so I'm pronouncing it, Jaha Martin with our kids.
Mhm.
What testimony do you think that witness can offer as related to your PCR petition?
Well, she wasn't here to be questioned. She's the one who done the initial interview. Several people, Miss Penny Hackett was there, and she was supposed to be the one that took the initial statements. I mean, they took the initial police report from her. It's in the presentation report, and no one even presented that at my trial, because it says that she alleged, that she says in statements in it that it says that I allegedly attempted to make the person do something. So it doesn't have the original statement. It didn't say that I did do it. The first initial statement in the police report doesn't say that. And that's one reason that needs to be clarified, because what did she say also at that interview? And what were the statements of her?
So it's your position that this witness, Jaha Martin, would be able to offer testimony that should have been offered at trial, but wasn't by Mr. Baum. Mr. Baum didn't call the witness.
Right.
Okay. Thank you.
Thank you, sir.
All right. State has no questions about that witness, so we'll move to number 7, Rebecca Underwood.
Yes. Mr. Reader, same question as it pertains to Miss Rebecca Underwood with the Department of Children's Services. What testimony do you think Miss Underwood can provide as related to your PCR petition?
I need to know if she did interviews with Mr. Barnhill or Miss Barnhill, or with NG. If she made any comments about Mr. Baum, which we do have records on that our aunt did, but supposedly she didn't. But I don't have her initial interview. And did they do it on recording? Because I know, because situations that have happened in my family, but I know Miss Galbraith does, the first thing she does an interview. So did she make a recording interview?
All right. So your position is that Miss Underwood could offer testimony about interviews of the Barnhills and the victim potentially?
On allegedly other incidents with Mr. Barnhill.
Okay, I got you. I got you.
And
All right.
NG.
And then Mr. Baum failed to do that.
Under Rule 412, yes.
Thank you.
Thank you, sir.
General, you have any questions on this witness?
You recall that this was litigated already and told that it was not allowed in? Anything that dealt with the Barn Hills and anything with that. Do you remember that being litigated?
I remember it being that Mr. Baum failed to put in a motion prior to 10 days, but then they allowed the state to do the same thing without the 10 days. So what's good for the goose is good for the gander. And on certain issues, they didn't, especially on my interview, they didn't put intent to use it or anything, or tell the judge that they were going to that until that day, and they signed a petition to keep Mr. Baum's statement out because they said Mr. Baum did not file under Rule 412. He didn't file within 10 days of the court.
Right.
But then the same thing, the state didn't do the exact same thing on other issues, but they allowed them to do it.
Well, I think that's probably because the type of motion that it was, specifically what a 412 motion deals with. But you do remember that this was something that was in fact discussed. And your issue is really that Mr. Baum failed to do something, correct?
Right. Well, Mr. Baum felt it, but Mr. Crouch made statements at the new trial when they discussed it. And then it could have been borne out by Mr. Wilson also if they put him on the stand. Again, they didn't put him on the stand, Mr. Wilson. And Mr. Crouch made statements that were actually not even in no paperwork that were presented to the court as an exhibit.
So, but why do you need this specific?
Under Rule 412?
So what you're asking is that your lawyer failed to file a
Oh,
Rule
I'm sorry.
12, Rule 412 motion. Is that it?
Yes, ma'am. He didn't do it for 10 days before trial. They let it come in. Yes, ma'am.
Okay, so that's an issue with your lawyer who had the information. All right.
Yes,
We'll
ma'am.
pass, Judge.
Yes, ma'am. I'm sorry. I'm trying to do the best I can. I'm not the brightest pumpkin on the farm. I've been through a lot, ma'am. I'm sorry.
All right, now we're at number 8, Rebecca Dawn Fisher.
Yes, Judge. Number 8, Mr. Reader, Ms. Rebecca Fisher. What testimony do you think she can offer or needs to offer as related to your PCR petition?
Miss Rebecca Fisher. Mr. Baum brought her back for new trial to ask her questions about her brother-in-law, which he called her uncle, which was not true. It upset her, and so she did say, he said the exact he said he's done this allegedly sexual complaints against your niece and stuff like that, and she said correct, and she said also, and he asked her again, and something to that effect, and she could say correct again. But then she said, after that, she said the statement that he's not my uncle, he's my brother-in-law. So the appellate court said that it proved biasness. I mean, it presumed biasness, but I couldn't prove the biasness, but because he didn't ask the exact offense and circumstances around the offense and the time and place of the offenses. He didn't ask those 4 questions. The appellate court laid those rules out in my brief.
So,
that he failed to do that.
so Mr. Reader, as it pertains to Ms. Fisher,
Okay,
Rebecca
Pumpkin.
Fisher,
That's why you
is
lost.
it your position that she could offer testimony that if she had been asked certain follow-up questions, that would have then disqualified her as a juror?
Yeah, under State versus Smith, it's unreasonable not to ask if you've been convicted of a crime, or you know anyone that's been convicted of a crime, or do you know anyone that's been convicted of a crime? And it goes into the federal level as well. Under State versus Smith, Faulkner versus State, Rollins versus State, and all those cases were overturned because of that particular issue. So anyway, getting back to the reasons why I knew God is because he didn't ask the exact offense, or he didn't ask what type of offense was, where it happened at, and the surroundings around it, and he failed to do that. And he failed to ask during the trial, have you ever been convicted I'm sorry. Has anyone you know have been convicted of a crime, or been a victim of a crime, or anyone that you know has been convicted of a crime, or have you been convicted of a crime? Which I just said it backwards, but anyway. Have you been convicted of a crime, or anyone that you know has been convicted of a crime is what the Supreme Court ruling says under State versus Mississippi. You have to ask that. It falls under through Johnson.
So your position is Mr. Baum didn't conduct enough voir dire with Ms. Fisher? Basically.
Judge Wolf.
Also, yes, and he didn't bore out, her testimony on that issue, and I had to get him for not asking the question as well. And you can't under 606B ruling, and the state's going to try to say, well, did you take it to the jury room with you? No, you can't ask it under 606B ruling. It's a federal court law under Wash versus state. You cannot even ask that question. And they're going to try to, it wasn't enough to affect it. And, you can't rebut that way because you can't even ask that question. Anything to do with on your mental process going into deliberation, you cannot do that. So there again, I'm just letting the court know that that's what they did last time when I brought back Ms. Fisher's. They told her, they said, oh, we credit her testimony because she said that she didn't take it to the delivery room with you. Well, under 606B ruling, which my attorney didn't appeal that the right way and put that in there, the 606B ruling, and say, well, they really weren't supposed to ask that question.
Okay. Thank you, Mr. Reader.
Under State versus Smith, 2011.
Senator Sagi?
Hey, Mr. Reader, so you referenced Ms. Fisher. We're talking about Rebecca Fisher.
Yes, ma'am.
And she was a juror at your trial. And you also recall that she was called as a witness at your motion for new trial. Do you remember that?
Yes, ma'am.
Okay. And at that motion for new trial, Mr. Baum actually called her as the witness. Do you remember that? Like
Yes,
your lawyer did that.
Yes, ma'am.
And he went to go ahead and ask her some questions about whether or not she knew you. And she said no, but her brother, that you might have worked with her brother. And that would be the only.
Did she really make that statement you just said?
So on page 15 of the motion for new trial transcript,
Because that's not what.
Rebecca Fisher, she's asked by Mr. Baum her full name. She says, Rebecca Dawn Fisher. Ms. Fisher, are you a juror at the trial in this matter? She says, yes, correct. Do you recall the time when the attorneys were asking questions of the potential jurors? That would be your jury selection. Yes, sir. And I believe, I don't know if it was me or General Crouch, were asking you questions about whether you knew Jimmy Reeder or not. And you said you did. She says, right. And I believe you said that you knew him because your husband had employed him at one time. She says, no, my brother. He worked for my brother, but my husband worked for my brother as well. And he says, okay, was that the only way you knew Jimmy Reeder? She says, yes, at the time, yes. I didn't know he had grown up with my brother, but he had grown up with my brother. And your husband, Will Fisher, yes, correct. And he used to deliver beer to H.G. Hills where Jimmy Reeder worked, correct? Yes. He says, I have no idea what route he drove. I have no idea. So your husband never talked to you about talking to Jimmy Reeder? No. And your husband also coached Abigail Reeder? Not that I recall. Your husband is a soccer coach? Yes, sir. Are you aware at the time Jimmy Reeder was also a coach? Yeah, a long time ago. Yes, sir. And there was a time when you were on the board of directors of the soccer league? Yes, sir. And you were still on the board of the directors when they ruled against Mr. Reeder on something and took out the 2-page ad in the Ashland City Times? No, sir. Like, do you recall this part of her testimony? Okay.
I mean, I didn't call the board to hear, but over that, but that's
Okay,
a false statement.
But
Allegedly.
and then it was already litigated about whether or not she knew a potential other witness in this case, Jody Jones, since that was discussed. And then when the last time was they talked about it, but this was all extensively litigated. And then of course at the they ask about Larry Fisher, your claims that he was convicted of a sex offense. And she corrected, he's my brother-in-law, he's not my uncle. Brother-in-law, yes, sir. And you didn't disclose that at the time of trial, correct? And she says, I didn't. I guess I didn't think anything about it. He's been put away a long time. So, and then Mr. Baum says nothing further. General Crouch gets up there. He objects to things under 606, but that was overruled. And General Krautz asks you some questions, if she had ever known the facts of the case. She says no. And he asked, did you go in with your mind made up whether you were going to acquit or convict Mr. Reader? And she says, absolutely not. And did you make up your mind after you heard the evidence in the case? She says, yes, sir. Did you deliberate anywhere other than in the jury room with the other jurors? No, sir. And then Mr. Baum asks more questions about extemporaneous materials. She didn't know what that word meant. Anything else that you didn't hear in the trial? Did they bring up life experiences? And he says, oh, no, sir. Mr. Baum asked, did you ever talk about your brother-in-law? She says, no, sir. Did any of the other jurors talk about personal experiences? No, sir, not that I recall. Did any of the other jurors mention that they might have known any of the witnesses that testified? No, sir. And that was their questioning. So basically, she's already been questioned about whether or not she was biased in the case or influenced, and she said no. You do recognize that she has.
You can't ask that question. 606 ruling says you
But-
cannot ask that question. The problem is, I'm saying that she didn't respond. Mr. Baum said he wouldn't have the opportunity because Mr. Baum didn't ask the question. He didn't ask, have you ever been convicted? Under State versus Smith, it's unreasonable not to ask that question.
Yeah,
Have you ever been convicted of this
Yeah.
crime?
Ms. Fisher's never been convicted of a sex
No.
offense.
Have you ever been a victim of a crime, or do you know anyone the victim of a crime? State versus Smith, words for words, what it says. And she did not. And because Mr. Baum failed to ask that question, but the other jurors, the public court recognized that the other jurors came forward, but she didn't.
Mhm.
And all the statements you just said practically are under the rule of 606B ruling. You can't even ask those questions, but they can't even take those into consideration.
But she never once said that she was biased or.
That's not the problem. She
Took it into
never had the
consideration.
opportunity to respond to the
We'll
question.
pass, Judge.
She never had time to respond to the question because it was never asked.
Right. Now we're moving to 9, Robert Fisher.
Can you fall back into that a little bit, please, sir?
With respect to, is it Robert or Roberta Fisher, the 9th one that you listed, Mr. Reader? I may have miswrote it. Is it
So
Robert
we can't
Fisher?
recalibrate on this real quick?
Let me,
Robert Allen Fisher. What
yeah,
are you
I'm sorry,
asking?
I'm talking about Ms.
wrote it.
Rebecca Fisher,
couldn't understand my own writing, Judge.
because she had skipped over some things that in her statements that wasn't actually, she just overlooked some statements that she said right here.
Mr. Reader, my question is related to Mr. Robert Fisher. What testimony do you think Mr. Robert Fisher can offer to the court as related to your issues raised in your PCR petition, sir?
The same as Ms. Fisher. They were brother-in-law and sister-in-law. Didn't come forward also about being brother-in-law and sister. Well, I think they should have. It makes the appearance of an unfair trial, state versus tape. You know what I'm saying? Just the appearance of them not even coming forward about that. They should have. But not only that, Mr. Robert Fisher, brother-in-law Larry Fisher was convicted of child rape and also incest, and he had 27 indictments.
So your position is that Mr. Robert Fisher could corroborate certain aspects
Well,
of,
I believe he might have worked for the county jail also, and we asked him, do you have any legal training? Have you worked for law enforcement? He didn't come forward about that. He also, his brother worked for Tennessee Corrections, and got allegedly caught having sex with one of the inmates and got fired also there. Larry D. Fisher did. Now, on top of the other issues, I have allegedly known that, and I can ask the question, Mr. Will Fisher, that's Rebecca Fisher and Robert Fisher's brother. And that's her husband, and his brother. And he allegedly did stuff to Mr. Will when he was a young boy. And they didn't come forward about it. And I can ask that question, because that's part of the State versus Smith question.
okay. Thank you, Mr. Reader.
Yanasagi.
So again, with this juror, your issue is that Mr. Baum didn't do effective questioning. Is that correct?
Yes, ma'am, he didn't voir dire on State versus Smith, and it's other, if you look into other Supreme Court rulings, other questions that you don't ask, that it can bring up any issue under biasness and unfair trial can also be under that same category.
That's all, Judge.
Right, we're about to start number 10. Let's take a short recess. So we'll take another 10-minute recess. My inclination is to go through all of these, not break for lunch. We'll just go through all, if there's 17 of them, we'll go through all 17 before we break.
All right.
All right, we now are, according to the list that I have, we're at number 10,
Number
Rick
10.
Hackett.
Yes, Judge. Mr. Reader, same type of question I've asked you previously with respect to number 10 on your list is a Mr. Rick Hackett. Can you please tell the court what testimony Mr. Hackett might be able to offer as related to your issues raised in your PCR petition?
Yes, I'd like to reflect at the end of this, please, sir. Go over something with my attorney. Mr. Hackett, I found out that he takes and he would ride home. Miss Barnhill would ride home with him from work when Mr. Barnhill was kicked out of the house he did take a charge on the other teenage girl, Tracy, that was in the house. Was a sexual assault that he pled out to 2 years and something.
Who pled?
Judge Jeanette.
I'm trying to understand what you're saying. You're saying that Mr. Hackett would ride with Miss Barnhill and he has knowledge of a charge that someone has?
He had knowledge of Tracy in the home. All this was going on because he gave Miss Barnhill a ride when Mr. Barnhill wasn't. He had to live in Kingston Springs, and he had to give her a ride when the state wouldn't let Mr. Barnhill stay in the house anymore because allegations of
Certain allegations.
Miss ENG on her as well, and he wasn't allowed to stay in the house.
So you're saying he's a potential fact witness as it's related to abuse allegations of the Barnhills?
Also,
Is that what, please tell me, is that what you're
during
saying?
his statements, during the voir dire, he was asked by the judge, he was asked by Mr. Barn, and I believe even Mr. Crouch, do you know any witnesses involved in this case? And he was asked, do you know any, they allegedly, I mean, some of the jurors came forward about, prior accusations. So what I'm saying is he was asked several times, did he know any witnesses? He knew the Barnhills, he worked with them every day. She was dispatched. He fell under her and talked to her not only during that, he also would occasionally give her rides home back to work, especially when Mr. Barnhill was kicked out of the home.
So you're saying that Mr. Hackett didn't answer truthfully as it relates to the Barnhills?
Exactly.
Okay.
And not only that, he didn't come forward about knowing the Miss Tracy and NG in the home. Also, he had knowledge of that because he's the one who gave Miss Barnhill and knew her situation and knew that she. I think this is all setting up the state to be able, even though we have to do this under their state. I just think it's setting up the state to be able to ask their questions the way they want to. But it's just, I know it has to be done. I just want to make a statement. I'm sorry. It's the way they want to, but it's just, I know it has to be done. I just want to make a statement. I'm sorry.
Okay, so your basic position is Mr. Hackett didn't answer the voir dire questions posed to him truthfully?
He didn't, yes, sir. He didn't answer the question about knowing the witnesses, Mr. Barnhill, Mr. Barnhill didn't get on the stand, so you can just check that one off because that's the way they did Mr. Jones in my appellate court record.
Okay.
But you can bring in Miss Barnhill because she was a witness involved in the case, and he knew about allegedly Mr. Barnhill, what he done with allegedly was Tracy and G.
Thank you.
And he cut the grass.
All right, General Sagi.
So, Mr. Reader, I understand what your claim is. Your claim is that Mr. Hackett wasn't answering questions in voir dire truthfully, correct? Okay.
Correct.
And then you said that you actually have proof of that. You have proof of this, or is this just things that you think about? Like
I have
the-
proof that he worked with T-Dot with them, and I have proof. I have proof of this, but I have to bring back to ask the question. Also, I have to bring him back to ask him, does he know anybody a victim of a crime, or has he ever been a victim of a crime himself? I have to ask that question because Mr. Bond failed to, and it's Supreme Court ruling that you have. It's unreasonable not to ask that question. And he knew about Tracy and he knew about NG. Also, he didn't come forward about answering the questions correctly. I'm alleging these in my petition, and I have to prove it when I bring them back.
You're aware, though, that your lawyer did actually ask questions of the jurors, asking them if they had ever been the victim of a sexual offense or had a hard time or like
No,
a
ma'am, he
bias.
never did. He never did. He said, this is his words. He said, do you have a belief that would make you believe alleged victim or Mr. Reader? That's all the statement he said about it.
So I'm reading the CCA opinion that you're familiar with, I know. And that you do acknowledge that your lawyer did ask the question, defense counsel asked, in your personal lives, has anyone ever been involved in some kind of abuse in such a way that would be more likely to believe an abused victim than Mr. Reader? Had some responses from the jurors, and some people got removed from the juror there.
Yes, ma'am.
And then other people were raising their hands about whether or not this sort of impacted them. We won't go into which ones they were, but then the questions were asked for new members. Is there any reason any of you can't serve? Carry any prejudice you can't put aside? And they all said,
Whoa. That's the last statement of Miss Fisher. He said any new members. The new members was Miss Fisher. The only one that was a new member was Miss Fisher. He said new members, and that was the last ones that he just called the three. You can't get that confused with
so your contention is that the jurors followed the request from your counsel by new members, meaning just that one, and nobody else could raise their
He said
hand?
for the new members, and Miss Fisher, he'd already addressed all the other ones. He's now for the new members. The new member was Miss Fisher.
And you do acknowledge that they did ask the question, that y'all have heard the questions I've asked. And
None of them answered the question.
Wait.
Let her
And-
finish.
Yes,
And
I apologize.
ask if they knew any of the potential witnesses. That's when Murray and Fisher raised their hand, and they stated how and why they knew that. So your issue here with Mr. Hackett is that he never told anybody he knew a potential witness. Is that right?
Mr. Hackett.
Mr. Hackett
Yeah,
didn't mention a witness.
yeah, he knew Miss Barnhill. He worked with her every day and she rode home with him sometimes and cut her grass, and he knew the alleged victim. Both of them, Miss Tracy Barnhill and Miss NG. And I just have to clarify because he was talking to the new juror, Miss Fisher, when he asked that question, but she never verbally, and it says you have to verbally respond and you have to do it. That it's the judge has the right to evaluate the demeanor and verbal response, and it's afforded differences under the federal court laws under OMS in my petition. And it says you have to do that. And they did not respond verbally. Even the court addressed and told Christina Hobbs that she needed to respond yes or no on the questions. And from that, they abandoned it through the whole trial. And none of them hardly responded to any questions verbally.
Okay, we do have a transcript of all of that. You do acknowledge that, right? Okay,
Yeah.
good. Well, that's what's wrong.
Right. Now we're at number 11, Kenneth Don Johnson.
Yes, Your Honor. Mr. Reader, regarding number 11, Mr. Kenneth Johnson, what testimony do you expect him to be able to offer that would be relevant as related to your issues in your post-conviction relief petition?
Say again, sir?
What do you expect Mr. Kenneth Johnson to be able to testify to
Well,
that
he
would
didn't
be?
respond to a question, even though I mean, if the state talks to him, I'm hoping that the judge will rule the sequential of the jurors and not let the state talk to him without his permission. I'm hoping that because he didn't acknowledge, he let me borrow one of his brakes. He was a contractor. I was a contractor. Mr. Robert Fisher was a contractor. You know what I mean? He'd been doing the same jobs I did. There's cases on that issue. He didn't come forward.
So you're saying that you had borrowed some equipment from Mr.
Yeah, a
Johnson?
brake through Steve Romans borrowed it for me through him to do Mr. Hunter's mom's house, which he was a juror too, which was kicked off. And he was in the courtroom that day.
So did
And-
you, let me make sure I understand this, but was there a third party that was involved? In other words, you didn't borrow it directly from Mr. Johnson, someone else borrowed it for you
I
from
mean, he
Mr.
knew-
Johnson?
I'm not sure if he was the contractor on that job or just Steve Roman was the contractor on that job, but he brought the brake to me and handed it to me. I mean, it might be casual exchange or whatever, the public court might say that, but I just want to know because he was the juror foreman, and I just think that he should have came forward, that he had some kind of interactions with me.
Okay, so you had a personal interaction with Mr. Johnson where you borrowed equipment from him and he
Right.
personally delivered the equipment to you.
Right, and then he wouldn't ask, does he know, was he ever been a victim of crime, or has anybody in their family ever been a victim of crime? He never was asked that question, and it's unreasonable not to ask that question under State versus Smith.
Did you mention to Mr. Baum, hey, I know Johnson, I borrowed equipment from him?
No, I didn't recognize him until later. He can say the same thing if the state talked to him, if the judge doesn't allow it.
Okay.
They won't be able to put that in his head, but he can say the same thing. All this stuff is happening so fast.
Thank you, Judge.
Mhm.
Peggy?
So Mr. Reader, for clarification, I want to make sure I get this right. You said that Mr. Johnson, Mr. Steve Romans, borrowed equipment from you or for you with Mr. Johnson. How did that work?
Mr. Johnson is a contractor also. He does a lot, which I was a home improvement contractor. He does, a lot of houses in Bordeaux and stuff. Steve Roman does a lot of his work for him. So he asked him to let me borrow a brake because I didn't have mine at the time, and he was going through some financial difficulties. And so he let me. He brought it and handed it to me and stuff. And I told him thank you and stuff like that. I just think him being the foreman, when you asked a question, do you know him? Or I'm saying that means, have you had any interactions whatsoever? I would think that would relate to that question as well. I mean, the public court will have to, or the judge will have to discern that or not. But I believe him being the jury foreman, because that it frowns on when a person is a jury foreman, it makes a bigger difference. And I'm saying his sister-in-law, I believe, is Pat Summit and stuff too. I'm not sure if she had any allegations against her. That's why I want to ask him, do he knows anybody that's been alleged of any crimes or been a victim of a crime? He needs to be asked that question as well.
Okay, so just to clarify, Mr. Reader, to make sure I understand what you're saying, okay? That your interaction with Mr. Johnson was very brief, right? You were just getting equipment.
Yes, I know that the appellate court frowns on that. I understand that, but still, he was a foreman, and they do frown on when it's a foreman.
Right, but because I've
Right,
never
right,
talked,
right.
I've never talked to you about this before, right?
Right,
And
right,
I need to make sure that I'm understanding this for
Right.
your claim. That he did borrow equipment. There was no issue with that. Like there was no fight. There's no physical altercation. There's nothing weird about that encounter with that foreperson.
No, but you're supposed to take your oath seriously, and when you're asked a question, you're supposed to come forward with it. And then hardly none of the jurors responded. He didn't.
And you also stated to counsel here that you didn't even recognize that Mr. Johnson was somebody that you had contact with.
Right, right. And
Then-
I'm hoping that you don't ask that question until the judge allows you to.
What?
I hope that under Thompson versus State, the judge has to give you permission to ask that question.
But
Thomas, I'm sorry. State
But-
Thomas.
let's just think about this too. Maybe Mr. Johnson also didn't recognize who you were.
That's what I'm saying. We don't know that fact until we ask him.
And you don't have any proof right now that he has ever been the victim of a crime or anything like that.
It seems like that it goes up to the 6th degree. If you look under the rules, under Rule 8, it goes
But
up.
I'm
it
asking
goes
you,
up to
do
6
you have
degrees.
any direct proof that he has been the
No, that's
victim
why I
of
allege
a
things.
crime?
But the point is, I have to bring you back and ask the question. Mr. Mom failed to ask that question. He forgot to ask, have you been a victim
So
of
this
crime?
goes really to your IAC claim that Mr. Baum didn't
Right. It's Mr.
thoroughly
Baum.
flesh
Yes,
that out.
yes, ma'am.
Okay, thank you.
That's what state representative says, yes, ma'am.
All right, number 12, Caitlin Crawford.
Mr. Reader, as it pertains to number 12, Ms. Caitlin Crawford, what testimony do you expect her to be able to offer that would be helpful to your petition?
Yes. Ms. Crawford, there it goes again. I didn't recognize it until after I started thinking about it and stuff. She had been at Head Start allegedly and volunteered at Head Start, where my daughter was one of the witnesses in the case. And she volunteered there. We did go one or two meetings, and because her sister-in-law and her sister or brother-in-law was trying to get back their kids in state custody. Now this is all allegedly, and she was there trying to help her get the kids back, and she was also asked if she had interactions with DCS, which some jurors did hold their hands up, didn't respond, what I think they should have, because that's what the law reads. And then again, like I said, she then again, I didn't recognize her, just like she can say the same thing on that. It's just a cumulative effect of these errors in the juror that's problematic, I think, because she asked me to come and bid on her jurors. I'm sorry. She asked me to come and bid on her gutters at her church on Jackson Phelps Road, which I did. I didn't win the bid, but I did have interactions with her in that sense as well. And her brother has been, or sister-in-law, so if I'm correct, which we won't know until they ask the question, if he's been convicted of multiple crimes, and they had a drug issue and stuff, and they had their children taken away from them and stuff, allegedly.
Okay, so you're specifically what you're saying with respect to Ms. Crawford is that she worked at the Head Start program where your daughter attended, correct?
She volunteered a little bit, yes, sir.
Right,
I
so
did
she-
too. I volunteered there. as
So there
well.
was some interaction there.
Yeah, I had 1,000 hours in.
And then two, you had dealt with her directly when you had made a bid to do some gutter work at her church.
Right, and she didn't come forward about, no, knowing me, she didn't come forward about, because she wasn't asked the question directly by Mr. Baum, has she been a victim of a crime, or has anyone in her family ever been a victim of a crime? I mean, of course, if it's unfair trial, other questions should have been asked as well.
Okay. And you're also saying that you know for a fact that she's either been the victim of a crime or people in her family have been convicted of crimes, is what you're saying?
No, because I didn't have an attorney to investigate, which is his obligation to do so, but he didn't.
I want to stay specific to Ms. Crawford. Are you saying that you know that she was either the victim of a crime or she has family members who were convicted of crimes?
As much as I can relate in my memory, I believe so, but I can't.
Okay.
I can't say for
And then-
100%, but I won't know until I ask.
All right. And then secondary to that, you're saying that Mr. Baum failed to ask her those questions.
Yes, sir. If it had been more investigation done, I wouldn't be here saying that stuff.
But at the time, you didn't recognize Ms. Crawford as someone that you knew during the voir dire process?
No, sir.
You didn't? Okay.
No, sir.
It was after the fact that you thought,
Right,
hey,
so-
I know Ms. Crawford.
Yeah, it happened
and-
so fast.
And this is how I know her.
I did, Miss Fisher, and I think I did. I can prove that I did, Miss Fisher, but I just knew her. I mean, when she came forward about that.
Thank you, Mr. Reader.
Yeah, thank you.
You know what I'm
And that
saying?
wasn't towards you, that was towards my other attorneys.
So again, just for clarification, Mr. Reader, your interaction with Ms. Crawford was at the Head Start where you picked your daughter up from school, right?
Mhm.
Okay. And was there any interaction there that was like hostile or negative, or were they just fine?
Well, I'm not sure if she did, but she was in the room when the lady that had her families had custody of them. They were trying to get back to TCS. She did. The lady bumped into me real fast, turned around and bumped into me, and we didn't say excuse me or anything. There was only wasn't very many people in there, and the lady over the Head Start brought it to my attention, and I was like, kind of like, oh, well, yeah, that did happen. And she said, well, y'all should have said, excuse me. I said, it was just close counters and didn't think nothing about it. So I'm thinking that, I mean, as far as I know, she could have been the one that called and complained on me.
But you didn't, like you didn't deal with her on a day-to-day basis with your children or anything like that. She wasn't like.
I had 1,000 hours in, and I don't know how many hours she had in, but I mean, a lot of it was my home studying with my daughter and stuff.
And your testimony too is that you didn't recognize who she was at trial, like you didn't tell your lawyer who she was?
No, she can say the same thing, but well, if but she's a Christian, she'll probably tell the truth.
But did you tell your lawyer at the time that you knew Miss Crawford?
No, I didn't. I didn't say that. No, I said I knew Miss Fisher. I did not know her. I knew her, but I didn't recognize her that day of the trial.
And then you said that you dealt with her maybe one day directly on a bid at the church for some work on the church. Is that correct?
No, she bid me to come bid on her churches. I thought all about it. When I started looking, what I did was I got the juror's name and addresses, from the clerk's office, and turned up part of the technical records where, we went over them, and I seen her address, and I got to thinking, I said, that sounds familiar. So I got to thinking in my memory, and so I remember going to visit her at the church on Jackson Fells Road and bidded on her. And then I got to thinking with the name and stuff, and started focusing more, and through some other people and stuff, and I remembered, and I mean, her brother, her sister-in-law, they are I've known them in the past, but I did not know that she was kin to them, you know what I mean?
Okay, so just to clarification, because you did all of your research after your trial.
Yeah, I've had to do everything. That's the problem.
How-
We wouldn't be here right now if it wasn't for that.
But at the trial, you didn't realize who she was?
No,
And
ma'am,
you
I
didn't tell
didn't.
her?
No,
Okay,
no.
thank you.
Right. Number 13, Tim Binkley.
Will you shut up? Now we see the violence inherent in the system.
He was not a sheriff at the time.
Yeah. Mr. Reader, as it pertains to number 13, Mr. Tim Binkley, please tell the court what testimony you think he might be able to offer that would be pertinent to or helpful to your PCR petition.
Yes, sir. First off, Mr. Tim Binkley, I admire him very much. He's a real respected man. But things happen fast in the courtroom. Everybody knows that. Mr. Larry D. Fisher worked for him, for the sheriff department. And he knows the Fisher family pretty well, allegedly, and he knows them very well. I think even Mr. Robert Fisher might have even allegedly worked for the litter detail and stuff for the county at one time. But working under, he was the head deputy, and he worked under him, to the jail and stuff. And Mr. Fisher was beaten pretty bad when all these crimes that he was indicted for. He was in the county jail, and they let him get the 2 charges for 16 years and then 4 years. And so he knew about Larry Fisher and their family when these questions were asked, or lack thereof. I just think maybe he could have came forward to the court, but everything was moving fast. But I just need him to be here as a witness to the fact that Larry Fisher did work for the sheriff department, and if to ask him if Mr. Robert Fisher worked for the sheriff department, because we asked him, do you have any legal training, or have you ever, worked for law enforcement?
So your position is Mr. Binkley could offer testimony to confirm that Robert Fisher worked for the sheriff's department, and then in turn, Robert Fisher should have answered, yes, I have or have had law enforcement experience.
That, and he knew about Mr. Larry D. Fisher's charges,
Right.
because he was the head deputy at the time of all these
Right. Okay.
charges.
All right. Thank you.
You have a second?
So, Mr. Reader, again, I'm just going to try to clarify this. You want now Sheriff Binkley, right, to be here to testify
Yeah.
about a person who was not a witness at the trial and it was not a juror at the trial.
He was a bailer. He was a party of the proceedings. They said parties. Do you know any parties? Robert Fisher knew him. He should have came forward about knowing him. You know what I'm saying? And also his brother, he knew all the legends of Mr. Larry D. Fisher. He knew that he worked for the county jail also.
Okay,
And-
so your assertion is that because Sheriff Binkley worked for the sheriff's office, that he is a party to the case?
Well, they said in the beginning of the voir dire, they named off all the parties involved, and they named off his name and said he was a party.
Okay.
In the beginning of the trial. They
Okay,
said, Mr. Tim Binkley's here, saying that, am I right? Do you know any of the parties involved in this case? And that means the DA's office or anybody else.
and he is in reference to Robert Fisher? Is that who is he in reference to for your case?
Robert
Fisher?
Robert Fisher is the juror,
Mhm.
and I was told that he worked for the litter detail for the county as well, and didn't come forward about being involved in law enforcement. That's part of law enforcement. But
So your issue is that Mr. Robert Fisher did not disclose prior law enforcement employment? Is that right?
mhm. And I think Mr. Baum should have followed up and asked if their families, were convicted. Were law enforcement as well. That's just what I believe.
Thank you, Judge.
All right, next one is Jason Matlock, number 14.
Mr. Reader, number 14 in your list is Mr. Jason Matlock. Please tell the court what information he might be able to provide that would be helpful to your PCR.
And excuse me if I'm a Matlock fan.
In February and March. And on the first interview, he kept trying to get me to make a statement on paper, but he knew I couldn't spell it well or write that well at the time. And he kept trying to get me to sign the bottom of it. And he said, well, we'll just fill it out. You can see in the recordings. He said, we'll just fill out the bottom. We'll do it for you. He said, just kept on knowing about that, and didn't even tell me until 6 minutes into the conversation about the legends. So I wouldn't read my running warrants on that particular thing. Then he brought me back. I came in voluntarily because they got Mr. Jones to try to record me at the muffler shop. And of course, Mr. Jones showed me the recording in his hand, and kind of backfired on him, I guess. I don't know what they were trying to get me to say anyway, but they asked me, did I make a statement about doing something as bad as a murder, which the jury heard that, and they don't have a clue. It's irrelevant. They don't even have a clue what it was about. It was having to do with Mr. Jones. And that statement was made on a phone call when he was in jail, which it did happen in a phone call.
But Mr. Reader, what I'm asking you is what specifically would Mr. Matlock be able to offer related to your PCR?
That's what I'm getting at. But he, that particular day, he said I was under Miranda warnings as well and stuff. But to get to the point, he said that we'll have to bring him in for those issues and ask him about particular questions that have to do with the Miranda warnings. But also we'll have to bring him back and ask him where he made, Ray Krauts said during his closing arguments that Detective Matlock said that he believed her. He never did say that on the stand. He looked at the transcripts. He never said, I believe the alleged victim, not one time. And Ray said that during his closing arguments. Also, he said, well, we could have indicted her. We could have indicted him for 10 counts of the C word, ILD, and you know, and then the R word. And we could have indicted him for that 10 times. How can you vouch for the credibility of an indictment? Yeah, you can indict a peanut butter sandwich is what some lawyers say, but there's no proof that I would have been indicted for more than what I was. But he said that on the record, and Mr. Baum didn't, clarify that, and other issues under prior acts. That could be some kind of the jury could have thought that was some kind of prior act, and that's in my petition as well.
Right. But what I'm not clear on, Mr. Reader, is what would Jason Matlock be able to testify to that would be helpful to the PCR? I'm not talking about trial issues. I'm talking about the specifics of your post-conviction relief petition. What testimony would he be able to offer, Mr. Matlock, that would be helpful to what you're alleging?
Well, because he made us, we can bring him on the stand and get him to testify that and show him with the transcripts and impeach his testimony that he did not say that he believed the alleged victim. He never said that, even though Mr. Kraut said he did during the closing arguments. Prosecutor misconduct.
Basically have him
making false statements.
You're trying to have him make a statement that conflicted with Mr. Crouch's closing argument.
Right.
The closing argument, that issue was raised during your appeal to the Court of Criminal Appeals.
But we had to get this straight right now. Anything that Mr. Baum did not put in my brief or did not kite the cases on it, and a lot of the agency didn't. He didn't kite the cases under Rule 10. The appellate court said he didn't do these things. Anything that the appellate court said he didn't do, I have to come back and get him on the post for, because he did not do several things or didn't go by the guidelines. Even the appellate court admitted to it on these issues. The appellate court ruled on what they had at their hand, but Mr. Baum only could put in because he was on new trial and he did the appeal as well. It's not weighed under the court rules, and I have cases to back that up. If your attorney is the same attorney in the trial, the same attorney in the appeal, it's missing many times, and it's not weighed. That's why it's why I say none of these issues that were raised at the appellate court that have rooted other issues or cumulative effects into that need to be addressed. That's why it's so important.
So I just want to make sure we're clear on this. I think I know what you're meaning, but I want to make sure we're clear so the judge can consider this properly. As it relates to Mr. Matlock, is it your position that if he was able to offer more complete testimony, you'd be able to then show that Mr. Baum should have included additional grounds in the appeal to the Court of Criminal Appeals?
Right.
Okay.
And also he knew about Larry Fisher's charges because he was involved in that as well. Larry D. Fisher, he was, saying he was a cop on that. Also, he knew about my learning disability because he's the one who knew about my learning disability. That's why he wanted me to sign the bottom of the thing. And it won't change the magnetation that much, but I mean, it could have. So,
okay. Thank you, sir.
All right, the next one is then Kenny Ray, number 15.
Mr. Reader, as it pertains to number 15, Mr. Kenny Ray, what testimony would you expect him to offer that would be helpful to your petition for post-conviction relief?
Be honest with you, it might be a lame duck, but he was in the courtroom the second day, July 5th, and Mr. Fouch knew he was his neighbor. He'd been knowing him for years, and there's not very many houses on Cagle Road. I just think for the appearance of a fair trial, when Mr. Ray came into the courtroom and the juror looked over at him and stuff, I just think, and then he heard him in the statements, that he was part of in the interview and stuff. I just think that Mr. Baum, should have asked, it was unreasonable for Mr. Baum not to ask, not only were they involved in law enforcement, but were anybody in their family involved in law enforcement? And I think that was also, and I say the public court or the Supreme Court would have to rule on it. Do they think it was unreasonable not to ask that question as well? I believe it was unreasonable not to ask for, is anybody that you know that's involved in law enforcement or anybody in your family is involved in law enforcement? And he knew. I just think that I would like to ask him, did he think he should have came forward when he seen Mr. Ray came into the courtroom about knowing him? And I think Mr. Baum should have asked the question.
So you're saying that Mr. Baum should have asked Mr. Fouch about his relationship with Mr. Ray.
Right.
I got you. And his failure to do so
Right.
furthers your PCR
Right.
petition.
And my petition says not limited to the jurors on bias issues in my
I
petition.
understand.
And I mean, I know it's sometimes the public court rules good on that. Sometimes they rule bad on the limited thing. That's how the jurors are trying to get in.
All right. Thank you, Mr. Reed.
Second.
Hi, Mr. Reader. I'm going to clarify this again because clearly I was not at your trial. So I'm
Right.
reading transcripts and everything else,
Right.
much like your attorney is. So I want to ask you a question. You said that Kenny Ray showed up on day 2 of your trial. Is that right? Okay. And you acknowledge that he was never listed as a witness in this case.
Yes, but he was in the statements that were produced in the court.
Okay, but he was not called as a witness and in the listing, because I went to go ahead and pull out what the court addressed the parties in there, including, we've already discussed Mr. Binkley, right?
Right.
And he introduced people on page 6 of the transcript. Good morning again, ladies and gentlemen of the jury pool. I want to introduce a few people. Of course, Circuit Court Clerk Jill. It says Jill Hibbs, but it should be Julie Hibbs. And myself, Larry Wallace. Standing to my left is Lieutenant Tim Binkley. Also in the back of the court is Officer Daryl Hooper. Standing to my right is, he says, Tim Binkley. Seated at the state's table is Assistant District Attorney Ray Crouch and Assistant District Attorney Danny Bryson. And Ashland City Detective Jason Matlock. Seated at defense table is Attorney James Baum and the defendant Jimmy Reeder. I believe that introduces it, and Kim Davidson, the court reporter. And then later on, there's some more discussion on page 9. The judge asked about potential witnesses and said, all right, ladies and gentlemen, I'm going to go over a few things. First, if the state would name potential witnesses. General Crouch said, Your Honor, the state's potential witnesses in this case are Jason Matlock. I'm going to give some initials. I think you know who they are. JG, JT, Kim Stringfield, Jeremy Etheridge, Holly Gallion. Your Honor, we may have some rebuttal witnesses as well. Do you want me to name those? And the court says yes. And he said, Ms. Underwood, James Snodgrass, Penny Hackney, and Jody Jones. And then your counsel was asked the same thing, potential witnesses. And Mr. Baum said, potentially recalling the Reeder children, Caleb, Gracie, and Abigail, and James Snodgrass. So those were what were read to the jury as potential witnesses for this case. And you acknowledge that the courtroom your trial is an open proceeding and anybody can come in and watch that, correct?
Yeah, but the removal of a biased jurors can constitute an interface to counsel. You know what I'm saying? The injunctions. I said the removal of a biased juror can constitute interface to counsel. It says we believe that a question that calls to a juror for responding who might be biased due to their past experience with our criminal justice system are critical part of a competent voir dire in criminal cases, and that absence of showing that a counsel had a strategy reason for not asking the question or failure to ask the prospective juror about their past experience with a victim or association with the victim is objectively unreasonable. I mean, he had knowledge of my case. He had done many cases. Mr. Ray did. And if he knew, my problem is, I just want to ask him if it's possible, if the judge allows it, did they have any communications?
Did who have any communication?
Mr. Fouch and Mr. Ray have any communications during the trial?
During the trial?
Yes.
Okay. Do you have any, do you have any statements that Mr. Fouch did communicate with somebody during
No,
this
but
trial?
it was just the way he made eye contact with him and maybe, and he came the second day of the trial. We can just, if the judge wants to, he can allow it or not allow it. I mean, it's not gonna hurt my feelings. I agree with you somewhat, but then I still think that Mr. Baum, it was unreasonable for him not to ask about, follow-up questions on if he would have, if he knew anybody that was involved in law enforcement, especially.
Okay, but just specifically for for Police Chief Kenny Ray, and Mr. Fouch, you do recognize that Kenny Ray was not a witness, or was not a witness for the trial or called as a witness, correct?
No, but he was involved in the statements that were produced at the trial.
Which Mr. Matlock was also
Yes,
present
both
for.
of them were. And that's the reason I need to bring him back also, because of the Miranda warning issues.
Thank you.
So I was informed that's concludes the list of cases that are witnesses that were on his 10/28/25 request for subpoenas. Are there others that he indicated that today?
Judge, I believe at the beginning, in addition to those 15 that we've just gone through, Mr. Reeder mentioned 3 others, which we've sort of talked about as it pertained to Mr. Kenny Ray. Number 15 was a Mr. Fouch.
All right, well, let's deal with them.
Okay.
Give me the first name that
Yep.
I'm gonna just ask your client.
Robert
directly.
Fouch.
Who?
Robert Fouch.
Robert Fouch.
Fouch?
Mhm.
All right. Who is Robert Fouch and why do you want him?
Robert Fouch Jr., he lives on Cagle Road. He was one of my jurors. And he was the one that, when Mr. Ray came the second day of trial, he gave me eye contact. And I just think that there's been other cases where jurors have come forward and he was mentioned during the trial, in the interviews and other issues. And I need to bring it back because of the Miranda warnings on Mr. Ray, but that's another issue. It's not, to move on where we can do things, I'll agree to waive, Mr. Fouch, and I'll agree to waive,
Well, Mr. Reeder, you also mentioned, in addition to Mr. Fouch, as possible supplemental was a Miss Thomas, I believe. Miss Thomas.
well, the problem is, Your Honor, if the law is correct, you have to tell me if it's not. Under State versus Smith, if my attorney did not, which we know he didn't, if he did not ask, have you been the victim of a crime or associated with a victim of a crime, then if he didn't ask any of the jurors that, my perspective is, I may be wrong, but if he didn't ask that question, that may be a public court ruling that needs to be addressed, but the law says it's
You're
unreasonable
wrong.
not to ask it. So if he didn't ask any of my jurors that, technically, I think he should bring all the jurors back and ask them the question he didn't ask them. If I'm right, I'm right. If I'm wrong, I'm wrong. But that's up to the court. But if the Supreme Court ruling, which it does, it says it's unreasonable not to ask that question, then how do I know if he would have asked that question if any of the jurors would have came forward with information that would have made me not want to pick them as a juror or
Right.
responded to the questions correctly?
So,
How
Mr.
do I
Reed-
know that?
So what you're saying with respect to Miss Thomas is that she should have been asked during voir dire
What was her
about
name?
Miss Thomas. What was, you know what her first name was, Mr. Reeder?
Teresa Thomas.
Teresa.
She worked, and not only that, she worked with my ex's aunt at the bank. Mr. Mom, I didn't find out till afterwards. I believe she worked, I don't know, I'm not 100% sure on this, but I'm pretty sure she worked with my ex's aunt. I believe I believe she knew me because I did a lot of transactions at the bank. Like I said, she didn't see me. I didn't see her. Who knows? But I just think if she remembered, she should have came forward
Ex-aunt?
about it. And maybe she overlooked it, or maybe she didn't.
Okay.
Maybe she was holding some kind of bias if she didn't respond to the question. I just would like the opportunity to ask that and ask, like I said, on the State versus Smith issue on
So-
the victim.
Specifically, Mr. Reader, you're saying that because Mr. Baum did not ask Ms. Thomas about whether or not she was the victim of a crime, or had family members who were victims of the
Exactly.
crime, that we don't know the answer to that,
Right,
but because she wasn't asked,
right,
that fell below the standard
right.
regarding the PCR. Okay.
And I mean, under the Faulkner, under Hale, it was overturned, of course. And then Rollins and all these other cases, they've just been overturned because of jury issues. And the Vanderbilt case is overturned because of one issue. Of course, that's just a persuasive case because it never made it to the appellate court. But we know the juror didn't come forward about one question about being a victim of a crime, and they overturned it. But the point is, I'm getting at is, it might be a question that needs more research, but it says plainly, if none of the jurors were asked that question, why shouldn't I have the opportunity to ask them? If Mr. Baum didn't ask it.
And then finally, Mr. Reader, what I'm going to call number 18, I believe you mentioned a Miss Gazea.
Ma'am, are you a whore?
Gazea or Gazea? Maybe I wrote it down wrong. Was there an 18th person that you wanted to have subpoenaed?
The ones we've already listed are the main ones.
Okay.
The Fishers and Mr. Hackett and Miss Caitlin Crawford and Mr. Robert Fisher, of course, and let's see, what was the other one?
Was Mr. Fouch and
Mr.
Thomas?
Fisher.
Okay,
Mr.
so there is an 18th. All right,
But the
so
other ones, I just think if the judge allows it for me to ask that question, or have you ever been a victim of a crime, or anyone in your family been a victim of a crime, I would like to be able to do it. I know that Mr. Elmore, he lives in Wayne County now. I don't know about his address or anything, so that's why I didn't even ask for him to come, and a few other ones. The only ones I wanted to come because there was multiple issues I thought that I could ask him. That Mr. Baum didn't ask me, like I said before, she worked at the bank and stuff. And then the one that worked at Vanderbilt University, well, what did she do? Mr. Baum did not even ask her what kind of work she was in. I mean, she might have been in some kind of child's associate degree, studying something about children or anything. And I should have known that. It's unreasonable for him not to ask that question. What do you do at your job? You work for Vanderbilt. I mean, you go to school at Vanderbilt, and most of them, a lot of the issues are about, medical issues. I just think he should have asked that question. That's the only reason on her.
So, Mr. Reader, I just want to be clear for the sake of the record and for the job that we're asking Judge Wolf to do. We've gone over 17 specifically named potential witnesses that you want to have subpoenaed in.
Right. What about Mr. Baum? Was that like?
Of course, Mr. Baum, of course, would be.
What about an expert? You said something mentioned about an expert.
Let me, what I'm asking you is, as it relates to the subpoena list that you sent in, we've just gone over the people who were specifically listed on that, numbers 1 through 15. And then we added number 16 and number 17, Mr. Robert Fouch and Miss Teresa Thomas. Were there any others that you wanted to add for the judge and the court to consider?
Oh, yes. The
Is what I'm
reason
asking.
the reason I wanted to bring back the jurors, which I have the motion over here, I wasn't able to finish it under. I've got the case over here, Your Honor. I'll be glad to grab it. It says that all the jurors heard the other jurors make statements, especially Mr. I got the motion over there. Especially one of the jurors, his name's supposed to, or hang on just a second, it'll come to me, Mr. Bryce, no, it'd be Mr. Bryce. Mr. Bryce went on and on about details about someone in his family from 30 years ago and made all these statements and stuff. Well, I have a case over here, Your Honor. I'll be glad to grab it. It says that if all the jurors hear the other jurors make statements that were prejudicial during their voir dire, and the judge or the attorney does not give instructions to the jury how to discern that information, then it was overturned because of that issue. And that's another reason I wanted to bring back the jurors, because, and I have the case over here, Your Honor, and the motion. Some of the spelling's not all the way correct, but it's pretty good. And I have the cases to back it up. And the issue, and I have the cases that says It's up to your discretion if you want to allow it into my petition, the day of the petition, without me having to modify it. But it is a strong issue, and it has been overturned, Your Honor, and it says that the court has to give instructions when there's so many jurors talking about issues, or even one, this particular, I think was one that made a comment about kind of like expert things, like the expert thing I'm going on the other things that happened in the Viadur with Mr. Douglas and Ms. Thompson. It's similar to that, but when a juror makes statements that things have happened in their past, or this particular case,
Are you saying these jurors made this statement during jury selection?
during the jury selection, the jurors were prejudicial because they heard statements from the other jurors about things that were similar to the case that was going on, and the juror and the judge did not tell the jury to either disregard it or how to interpret that information, and the case was overturned. I have the case right here, Your Honor. Anytime you want to see it, yeah, I can grab it really quick. It's right here on top.
Those are my
Roman,
questions.
it's Roman, State versus Roman.
Thank you, Mr. Reed.
Sorry, what was the name of the case? Did you just say the name of the case?
Yes, ma'am. State versus Roman.
Roman?
Yes, ma'am. I believe it's 2014 or 2012. Let me see. I got it right here.
Any other questions, Ms. Segi?
Just clarification, for the last, we had Mr. Couch.
Wait, we're waiting for Ramen here.
Thomas or is it
Ms. Thomas.
Thomas?
Mhm. I would like to bring them all back, Ms. Thomas too, but I mean, because of, the reasons I've said. I mean, the appearance, I just think the appearance of a fair trial has not been said. For the record, I just want, like you would want, the judge would want, anyone here, I want a fair trial. And I don't believe I was given that. That's all I'll say.
All right, step down.
Oh, I'm sorry. Yeah, I can't hear.
Amazing. Brilliant.
This case has been pending for, I guess it was some 8 years or so. Actually, the convictions were entered in July of 2013 when Mr. Reeder was convicted of rape of a child and sentenced to 25 years on counts 2 and 3 that were merged together, and aggravated sexual battery 10 years. That was to run consecutive to, so that he's got a 35-year sentence essentially. But this case has been pending since for some 8 years or so on the post-conviction relief, having all of his appellate methods, procedures having been affirmed by the Court of Appeals. So this court was not the trial judge who heard this case. And as a result of that, there is a voluminous file containing transcripts. Each one of the petitions for order for post-conviction relief are in and of themselves a volume that will require a great deal of time to go through. In other words, the determination of whether or not these witnesses are relevant and therefore admissible is something that the court will have to take under advisement. And I'll have to go through the transcript of the trial to be able to determine whether any of these people's testimony would relate to the issues that were raised in the third amended post-conviction relief petition. And it is
I can
only
do it
those
in about 5
witnesses who
minutes.
will relate to the issues that were raised, and those issues that were raised that are legitimate under the post-conviction relief statute would be considered. So as a result of that, I will take this under advisement. I'll try to get a ruling as quickly as I can as to which of the witnesses can or cannot. And as I explained, we'll set a hearing date for the, once I have that order down, we'll set the hearing date for the hearing on the order on the.
That's it.
for
Alyssa's banned for life.
In the interim, Mr. Saul will remain as your attorney It appears to me that perhaps today you've seen how an attorney can assist you in presenting your case, and for that reason, I'm not going to relieve him. But this concludes our hearing for today, so therefore this case is continued until such time as I issue that order, and then we'll set a hearing date. We stand adjourned.
All right.
Well, that was just horrible. Let me see. Let me see if I can make it up to you here. I don't know. Let's do this.
Court does call the case, People versus Dwight Miller.
People.
Good afternoon, Your Honor. Rob J. Killwald calling outside of Judge Clay's courtroom. Good afternoon, Your Honor. Dwight, would you state the record?
I'm American State National. I'm appearing sui juris. You is not my attorney. That's not working for me. We got a whole issue. All my constitutional rights have been violated. I want it on the record. I was arrested by a lie. I want it on the record.
Okay, first of all, I'm going to stop this. I directed this defendant to be in this courthouse in person.
I got a bad back, sir.
And he is not here in person.
Sir, I
am not going to sit here and listen to him ramble on and on about everything.
Oh, really?
I don't mind hearing from people, but I take it. If you're going to say it all, you're going to say it to my face. Bench warrant will issue for defendant's failure to appear. No bond.
I am here.
We'll get him here.
I got a
Thank you. You can mute him. Thank you, Mr. Killawald.
Okay, Judge. Thank you. Judge, if I may say, he does have some medical issues. That being said, all I wanted to do was set it for exam.
Well, when he gets here and graces our doorstep, I'll be more than happy to set it.
All right, I'll bring my constitutional book. Thank you, Your Honor. Thank you.
All right, thank you, Mr. Killawald.
Thank you, Zach. That was fantastic, and we needed it. We really, really did. We really did. Let me see if I've got something. Yeah, it's time. It's time for some.
Yo, turn the beat up in Vaughn's dictionary.
Take you out with that. Thank y'all for hanging with me. That was rough.
Step in the courtroom.
Started strong, faded.
Speaking like logic got evicted. Mirandarization, boy, that ain't a word. Whole jury laughing like, what did we just heard? Unlogical motions, compellment too. He reiterate nonsense like deja vu. Try to squash, not quash his own case in flames. Even spell check filed the motion saying, bruh, that's lame. It's a moot point, baby, sinking in the trial. Sherrick Vaughn freestyle, but it's juvenile. Tried to recruit the judge, the clerk, and his crew. But the only thing recused was his brain from the view. Dixon, Tennessee, home of bad boy blunders. Vaughn taking L's like his courtroom thunder. Fired his lawyer, then begged for a hand. Elbow counsel stuck like, bro, this ain't the plan. He's pro se, no way, thinking he's slick. But he's playing Uno while the court plays chess quick. Every motion's a joke, every word's a crime. Even Dr. Seuss said, man, that rhyme don't rhyme. Requise, recruise, make up what you choose. But every fake word just adds to your blues. Mirandarize this, moat point that. Sherrick Vaughn rap dictionary looking flat. It's a moat point, baby, sinking in the trial. Sherrick Vaughn freestyle, but it's juvenile. Tried to recruit the judge, the clerk, and his crew. But the only thing recused was his brain from the view. Mirandarization, unlogical station, compellment nation, courtroom clown in rotation.